Hey guys, it's Ethan, and today we're going to be going over the documents you need in order to make an offer on a home. The first document we're going to be taking a look at is the disclosure regarding real estate agency relationship disclosure, and the purpose of this document is to establish the responsibilities and the duties of both the buyer's agent and the listing agent. Both the listing agent and the buyer's agent have a responsibility to be diligent and exercise reasonable skill and care with everything they do. They have to be honest and fair to everybody in the transaction, and then lastly, they have to disclose all facts affecting the material value of the home. This next section, called Agent Representing Both Seller and Buyer, covers the concept of dual agency, and dual agency is when a single agent represents both the buyer and seller in a transaction. This is legal in California as long as both parties understand what it is and consent to it. Dual agency can be a bit of a conflict of interest because when a single agent represents both the buyer and seller in a transaction, it can be hard to keep both parties' best interest in mind when they probably know confidential information, which would skew the transaction towards one party's favor or the other. This last section, titled Seller and Buyer Responsibilities, is pretty self-explanatory and it just goes over a lot of common sense. So for example, if your agent gives you a document to sign, make sure you read through it fully before signing. If you have to fill out any information, make sure you fill it out truthfully and without lying. And then lastly, if your agent gives you a task to do before the close of escrow, make sure you do it in a timely manner so as not to delay escrow and so that you can close on time. Next up, we have the Fair Housing and Discrimination Advisory. And again, this is a really self-explanatory document going over some common sense. As a buyer or seller, you cannot discriminate against anyone based on anything in this box right here. So race, color, ancestry, national origin, etc. Just don't discriminate against anyone. The possible representation of more than one buyer or seller disclosure, or PRBS, states that a single broker or brokerage is allowed to work with multiple buyers and sellers. It covers the concept of dual agency again, and it states that offers are not necessarily confidential. So when you offer on a home, just be prepared for your offer details to be shared with other people because this is allowed. The wire fraud advisory is a warning to you to be careful when you're wiring in your EMD or your down payment. There are scammers out there that somehow find out that you got into escrow, and so they pretend to be an escrow company and send you fake wiring instructions so you can send your money to them. Before you wire in any money, just call your agent and have them verify that the wire instructions are legitimate. The buyer's investigation advisory is a warning to you as the buyer to do your own due diligence. It's not the seller's fault if you miss something in the disclosure package that they provide, so do be sure to read through everything thoroughly and make sure to ask your agent any questions. The Fair Appraisal Act addendum applies only if you're using a loan to purchase the property, where the bank would require you to get an appraisal done in order to give out the loan, and it's just saying that the appraiser is going to be providing a third-party objective opinion on value that's not influenced by any other parties. The California Consumer Privacy Act advisory states that when you're buying or selling a home, your personal information such as your name and your phone number might be shared with other people like the MLS, other real estate agents, or other escrow companies. The buyer contingency removal is a very important document, and on here you would indicate what contingencies you would be removing from your offer. The additional agent acknowledgement is pretty self-explanatory, and on this document you would just indicate if you're working with multiple different agents to represent you on the same property. Finally, we have the California Purchase Agreement, and this is going to be your most important document of all. It's going to hold all your offer terms, what your offer price is, and it's actually a legally binding contract that you make with the seller. Sections 1 and 2 are pretty boilerplate and outline who the offer is from, what property you're offering on, who the agents are, and who they're representing. Section 3 is where things start to get really important. This is where you start covering offer details, and I'll go through each box with you so you understand what's going on. Part A covers what purchase price you're offering on the home, and Part B covers how many days you'd like escrow to be. Most likely, if you're all cash, you can close between 10 to 15 days, but if you're using a loan, it's going to be twice as long, so 28 to 31 days. And the reason why is because the lender needs to do a deep dive into your finances, they need to approve the loan, and usually that paperwork takes a long time. Part C is your expiration of offer box, and it indicates to the seller exactly when your offer expires. And Part D is your initial deposit amount, which is usually going to be 3% of the purchase price. This is going to be a small amount of money that you put into escrow to show the sellers that you're serious about buying the property. If you're using financing to purchase a property, Part E1 is going to explain to the seller what type of loan you're getting and how much you're putting down. Part E2 indicates if you're going to get a second mortgage to help pay for the down payment, as well as the details for that loan as well. Part E3 is going to indicate what type of property this is going to be for you. If it's a primary residence, you don't have to do anything, but if this is a second vacation home or maybe an investment, you would indicate that in this box right here. Part G1 indicates if you'd like the seller to give you a credit up front, but usually this box really isn't used because it makes a lot more sense to just offer a lower price. Part G2 is never really used, but it's just a box where you can indicate any additional financing terms. Part G3 can be complicated to explain, but to sum it up, the buyer's agent is paid for by the seller. When the seller signs a listing agreement, in there is a clause that states, hey, the listing agent is going to be getting X% of the purchase price of the home as compensation, which is going to be split 50-50 with the buyer's agent. You would check this box right here in case the seller or the listing agent want to compensate the buyer's agent in a different sort of way. All of section H is pretty self-explanatory, and here you would indicate to the seller how long you need to provide proof that you're able to buy the home. Ideally, you would attach proof right to the offer, but in case you need a couple days, here you can indicate, hey, I need 1 or 2 days to get my pre-approval letter to you, or to send you a screenshot of my bank account showing that I have enough funds to close. Part J is your final verification of condition box, and this states that you have a default of 5 days or X many days prior to the close of escrow to go into the house and do one final inspection just to verify that the property condition is largely the same as when you first saw it. Part K is your assignment request box, and the best way I can explain this box is with an example. So let's say you're buying a property and your Aunt Sally says, hey, I want to step in and buy this property instead of you. You're allowed to assign the property sale to her, therefore making her the buyer of the property. Section L is your contingency section, and this is going to be arguably one of the most important sections of the entire purchase agreement. A contingency is a period of time that allows you to back out and still keep that 3% deposit you put into escrow in the beginning. So if you choose to waive contingencies, that 3% deposit is at risk immediately, and if you choose to back out, you're not allowed to keep it. There's 3 contingencies that hold the most weight on a purchase agreement, and those are going to be your loan contingency, your appraisal contingency, and your investigation of property contingency. The loan contingency allows you to back out of a deal in case you're denied for a loan. Your appraisal contingency allows you to renegotiate or back out if the property doesn't appraise. And then lastly, your investigation of property contingency is going to hold the most weight, and it allows you to investigate the property in any way. So you can get any inspections done, you can go take a look at the property yourself, you can take a look at the disclosures, and if you find anything you don't like, you're allowed to back out of the deal. Keep in mind that because this contingency is so powerful, when you include it on an offer, a seller is going to be very wary and cautious of it. And if you're in a multiple offer situation, having this on your offer is going to put you at a steep disadvantage compared to the other offers. And lumped together with L3 is the informational access to property box, and this is just saying that the seller is legally obligated to give disclosures to the buyer. So things like HOA docs, things like the TDS and SPQ, the seller must disclose these to the buyer in order to close escrow. Part L4 is the review of seller documents box. This is just saying that the buyer has 17 days or X many days to review all seller disclosures, and then based on anything in those disclosures, the buyer is allowed to cancel if they don't like anything. And again, if you include the investigation of property contingency, you don't really need to include this contingency because it's covered under investigation of property. Part L4 is the review of seller document box, and this is just saying that the buyer has 17 or X many days to review seller disclosures, and then based on anything in those seller disclosures, they're allowed to cancel. And again, this is covered under investigation of property, but if you would like to include it separate, you're allowed to underneath. Part L5 is the preliminary title report box, and this allows you to pull out of the deal in case there's any issues with title to the property. Now, with that being said, 99% of properties that I've ever seen already have a preliminary title report pulled before they even list the property. So you can review chain of title and make sure that everything looks okay before you even make the offer on the home, and this box is never really used. Part L6 is your common interest disclosures box, and this allows you to pull out of the deal based on anything on the HOA docs, but it's never really used because 99% of homes in Santa Clara County already have HOA docs posted online or in the disclosures, so any red flags can be spotted before you even make the offer. Part L7 is your review of leased or lien items contingency, and it only really applies if there's any leased solar panels or leased propane tanks that are going to be included in the property sale. It gives you a period of time to just review those leases, and if you find any red flags, you're allowed to cancel. Part L8 is the sale of buyer's property contingency, and it would make the sale of the house contingent on the buyer selling their current house. For example, let's say you're a buyer that's already in the market and you find the perfect place that you want to put an offer on, but the issue is you already own a home and you don't have the money to just buy 2 houses at once. You can make an offer on the new property contingent on the sale of your property, and this way you can protect yourself in case you list your home on the market and it doesn't sell. Section M covers possession of the property after close of escrow. 99% of the time, the buyer is allowed to occupy the property right after the home sale is recorded with the county, but in case the buyer needs to change that time, they're allowed to indicate that in box M1 right here. But let's say the seller needs a couple more days or a week or two to leave the house, you would indicate that in box M2 and attach the SIP form, and on that form you would indicate details of the seller leaseback, such as how much compensation the buyer will be getting in return for the seller still occupying the property after close of escrow, or even what day and time the seller needs to leave the house, and it would work much like a lease agreement that would be very short term. Box M3 would apply if you're buying a property with a tenant inside, in which case you'd attach the tenant occupied property addendum, and this document would just detail who's occupying the property, their names, as well as their personal information. Section N specifies when the seller must do things like give you any and all disclosures on the property, give you escrow information, or even give you the HOA docs so you can review. If the seller misses any of these deadlines on the right, you'd be allowed to file a notice to perform and potentially cancel the sale. Moving down to section P, and before I go over this section, I want to go over the difference between real property and personal property with you. Real property are things like land and any structures built on top of it, and personal property is considered anything that you can remove from real property, so things like kitchen appliances, any personal belongings, these would be considered personal property. Section P just goes over what personal property is included with the sale. So you can specify that the stove, the fridge, the washer, and the dryer can be included with the home sale. Section Q goes over closing costs, and generally these aren't negotiable. These are determined by what county you're buying the house in. If you're confused on what closing costs you have to pay for, you can go onto any titles company's website and find a guide similar to this one. And to give you an example, if you're buying in Santa Clara County, this is what's called a seller pay county, where the seller would pay for escrow, title, and transfer tax. But if you go somewhere like Santa Cruz County, these costs might be split 50-50 between the buyer and seller. So just keep these in mind when you're trying to estimate closing costs. I did want to pay special attention to box Q18, which is your home warranty plan box, and it indicates if you're buying a home warranty plan as well as who's paying for it. The difference between a home warranty and a home insurance plan is that a home warranty would cover things like your appliances, your plumbing, and your electrical system, things that a regular home insurance plan wouldn't cover. And the reason why you'd want one is because if you're tying up a lot of your savings into the down payment of the home, the last thing you want is for a $9,000 bill to come up in case the furnace breaks. And so I always recommend all my clients purchase a home warranty plan. Moving down to section 4, this isn't really important for you to pay attention to. Your agent would only use this if extra paperwork needs to be included with your offer. So for example, if you're buying a home with tenants, if you're buying a home that's under probate or a manufactured home, usually offers like this need extra forms, so you would just indicate that here and attach the filled out addendum with your offer. Section 5 and below is just a further explanation of everything that I went through above. All of these definitions are a little bit confusing to read and they're full of legal jargon, but if you want an in-depth and full explanation of any of the contingencies or any of the details of your offer, be sure to reference these as they might help you. Sections 29 and 31 are two sections that I do want you to pay special attention to because they do look a bit intimidating, but I'm here to explain each one to you. Section 29 is your liquidated damages clause, and it states that if a buyer and seller are in contract and you guys fall out of contract due to the buyer's fault, then the seller is allowed to keep the buyer's deposit up to 3% of the purchase price. Section 31 is your arbitration clause, but before I go over it, I want to go over the difference between arbitration, mediation, and litigation. Mediation is when a trained professional acts as a neutral facilitator that guides a discussion between two opposing parties to hopefully come to an agreement. But the thing about mediation is that that facilitator is not allowed to make a binding legal decision. Arbitration is a sort of expedited trial where a single individual, much like a judge, is brought in, hears both sides, and makes a binding legal decision. An arbitrator must be an actual attorney practicing law for at least 5 years, and arbitrators are employed and assigned by the state of California. Finally, a civil suit is a lawsuit carried out in an actual courtroom where there is a jury, there's a defendant, and a plaintiff. The reason why you would choose arbitration is because usually it's a lot simpler than litigation, and it would save everybody involved a lot more time and money. If both the buyer and the seller sign Section 31, you're both foregoing your right to a trial by jury in favor of going straight to arbitration in case any legal issues come up. It's my duty to let you know that this box is optional, but I will say that if you do choose to leave it blank, it might come off as a little bit unusual to the sellers, and it might even affect your chances at getting your offer accepted. Finally, these last 2 pages are also for clerical purposes and generally unimportant. They're just signature pages for everybody to sign and fill out.